Hello, everyone. Welcome to Ignite Legal Tech Innovation Day One Teaching Tech. This is the Teaching Tech first day, which runs from approximately now to 1 p.m. I know it's early in the morning for some people out there across the country, very, very early in the morning here on the East Coast. But we're going to start right now so we can get this going at 8:30, which is the designated time for our first presenter. We have today faculty who teach in the area of legal technology, and they've come together today to discuss their methods, their way of teaching technology in their law schools. And we're going to explore with you during these sessions, 3 sessions and 6 presenters, how to teach technology in a competent way in law school. There are only so many hours in the day and only so many hours in a law school classroom. Nevertheless, technology competence in the law needs some affirmative steps to bring practice-ready attorneys before the bar. Ever since the American Bar Association modified competence model rule 1.1 comment 8, requiring lawyers to keep abreast of changes in the law and practice, including the benefits and risks associated with relevant technology, there has been some additional progress regarding teaching legal technology in law school. However, it still has a way to go. Mandates we've seen, like email service of pleadings and required e-filing, have also prompted further attention to know-how of technology in the area of the law of practice for attorneys who are currently practicing in corporate and the courts. Casey Flattery, outside counsel for Kia Motors, has created technology audits for Kia Motors' many outside law firms. When asked in which technologies should a competent attorney be proficient, his general response is if you are capable of serving your client more efficiently using technology and you refuse to learn how to use that technology, you are overbilling your clients. As you may recall, in early January of 2019, Paul Manafort's attorneys filed a response to claims made by special counsel, Robert Mueller. It was soon discovered that whomever redacted the document failed to do so properly, allowing anyone to read the redacted text by copying and pasting the blacked out sections. While there is likely some staff member who took the hit for this inside the firm, as you know, and law students should know going forward, if you are the attorney who signs the documents and take responsibility for the contents of the documents. Currently, only 12 states have not adopted Rule 1.1 Comment 8 or some similar state-created facsimile based on Rule 1.1 Comment 8. The vast majority of states are now offering more CLEs in technology. I know that's the truth in Ohio, where I am asked occasionally for some technology hours during a CLE day of CLE. We have 2 states, Florida and North Carolina, that do affirmatively require CLE hours in legal technology. And New York Bar Association within this past year has proposed a more limited CLE requirement, recommending 1 hour in cybersecurity. I think this is the trend. But where should technology competency training begin to shape competent attorneys, to create the competent attorneys we need today? Law school is a logical response. So how are law schools reorganizing and recognizing the integration of legal tech in the practice of law and responding to it? Here today are expert faculty members who are going to offer you their examples of what they're doing at their law schools, and we hope that you will ask questions, comments, and provide your examples if you teach in these particular areas or want to teach in these particular areas. Law students may keep pace with the newest iPhone or their newest social media profile, but that is not what we're talking about today for students. So how do we create that competency for students? We look at law schools. Law schools are looking more and more to be the place where this technology and innovation can be delivered to students. Lawyers today need to be more than just knowledge aggregators, which they have been for a long time, right? Just a wealth of knowledge or ability to get that knowledge in a quick and efficient way. But clients, and sending that knowledge out in memos and letterhead. But clients nowadays, their value, as they see it, astute clients are wanting the form of tools and solutions, right? They want to receive that type of information, the data itself many times. This value-added approach starts in law school, and we start teaching that in law school. Actual instructional programming from e-discovery to developing automation systems, processes, to how to streamline client services is happening. Negotiation, investigation, fact-checking, legal research, and so on, take on the legal technology demands, which can develop a more well-rounded attorney. One that is attractive, a new attorney that is attracted to firms, corporations, and government work in need of the next generation of attorney. Today, we have before us 6 people offering what they have done in law school, teaching legal tech. And just a brief note to those attending today, we did have it set up in the program as concurrent sessions, sort of like an in-person conference, which we're used to, right? Pre-COVID, where you can go to one room or another to see different programs. In this case, that's not going to happen. Last week, we did a run through and we found out that to do this particular type of conference, we'd have to have all viewers have the latest version of Zoom, and we found out that would be impossible. So we moved to this from concurrent to consecutive. So I was going to give, and all 6 of us were going to give a 1 hour and 15-minute presentation. Now that's been cut to 35 minutes. But I think this is good because after so long, it just gets to the point where I in e-discovery was just trying to find things to fill that time. So moving forward today, the 6 areas that we're going to cover are first, I'll just list who's going to be coming up and in what order. First, we have Robert Fernier, Director of the W. Bruce Lunchford Academy for Law, Business. It's kind of hot in this room. I should have done something. Business and Technology, and Director of the Small Business and Nonprofit Clinic at Northern Kentucky University, Chase College of Law. He will be presenting Teaching Blockchain in Law School. And then I come up next. I've already introduced myself, and I will be teaching e-discovery in law school. Then after the break, coming back at 10 a.m., and if our sessions go past, our 35 minutes or so, we will take that 15-minute break and shrink it accordingly so we stay on time with the program. At 10 o'clock, you'll tune in to hear Kevin Ashley, Professor of Law, University of Pittsburgh School of Law, present on teaching applied legal analytics and AI, artificial intelligence, in law school. Next, we'll have Emily Janowski-Heelan, Associate Director professor, I'm sorry, Emily, and director of the Law Library and Associate Dean of Academic Affairs and Institutional Excellence at the University of Akron School of Law. She'll be speaking on teaching cybersecurity, internet privacy in law school. Then after another break, we come back at 11:30 and we will finish with two more presenters. The first will be Heidi Kuhl, the current circuit librarian for the 8th Circuit in 7th Circuit, pardon me, 8th Circuit is in St. Louis, the 7th Circuit in Chicago for the U.S. Courts of Appeal. Ms. Kuhl recently had been the professor of law and director of the David C. Shapiro Memorial Law Library, and she will be speaking on teaching case practice management in law school. Then the next presenter will be Roger Skalbeck, professor of law and associate dean for library and information services at the Richmond School of Law. Professor Skalbeck will be teaching on teaching tech competency in law school. And what tech competency today in law school is a very important matter. And we hope that you'll stay for Mr. Professor Skalbeck's teaching. If there's any time left after 12:45 p.m., we will have some closing comments and then take any other questions, comments, or any questions some of our presenters did not have the chance to get to at that time. And so we're coming up just a minute away from our first presenter. That's Bob Furnier. No, you're not Bob Furniture. I'm sorry. I'm Joe Customer. Bad. But anyway, we have Bob Furnier to tell us about teaching blockchain in law school. So Bob, I'll hand it over to you.
Good morning, everybody. As Joe said, I'm Bob Furnier, and I'm from Chase College of Law. I also teach at Southern University Law Center as adjunct faculty. It's an HBCU law school, and that's an interesting story that I want to talk about in just a little bit. Today, we're going to talk about teaching blockchain in law school. Tomorrow, I'm on a panel, one of several panels that actually take a deep dive into the technology and its impact on the law. My focus today, and I suspect it's the focus of my colleagues, is on the challenges of teaching technology like blockchain in a law school environment. Joe, is it all right, Marty, if I share my screen so I can have a PowerPoint in front of me?
Sure.
Yeah. Great. Hopefully everyone can see that, and I can start here. So as I mentioned, tomorrow we're going to talk a lot about blockchain, and I'm only going to mention enough about blockchain to probably confuse you and just kind of give you a foundational knowledge. But if I could, I wanted to take a moment and tell you how I got to where I am, because I think it's important for those of you who aren't teaching right now, but think you might want to get into teaching technology. I've been practicing law for almost 40 years. I've had a strong interest in technology. I have been very active in the American Bar Association. I was vice chair of ABA Tech Show board. I was on the e-learning task force. I've been on the Law Practice Division Futures Committee. So I've spent a lot of time thinking about technology and its impact on the law. And when I was asked to teach at Chase, it was originally as an adjunct in January of 2017, when the Lunchford Academy actually launched at Chase College of Law. And later that year, the director left, and the dean asked me to assume that role, and I became the director of the academy. And essentially, what it is, it's an honors program that tries to blend in those three elements of law, business, and technology. And because of my focus in my career on technology, I was very interested in doing this. And at the time, we only had some very rudimentary technology courses. And then the dean came to me and indicated that he wanted to create a law and tech curriculum, primarily for the Masters of Legal Studies program. And so I was commissioned to develop an online curriculum, and that's what brought me here today. I developed and helped get approved 7 courses, or actually 8 courses. One is a seminar in tech. And we launched 2 years ago, 2.5 years ago. Now we're almost at the end of the summer, but the summer 2 years ago, and we've gone through 2 cycles. We teach the class primarily asynchronously online. At any given point in time, we may have as many as 4 classes running simultaneously because it's asynchronous. And the way we developed the technology was to focus not on a particular technology like artificial intelligence or blockchain, and offer a course like blockchain on the law and the law, or artificial intelligence and the law. But instead, we structured the curriculum around the core courses like criminal law, torts, contracts, civil pro, and then we would create courses that survey technology that had an impact on those areas. For example, we have a course called Digital Crimes and Torts that kind of expands on what students might learn in crimes and torts. Well, and one other thing, I also teach and help create the Urban Law Technology and Research Academy at Southern University Law Center in Baton Rouge. And I'm going to talk a little bit about that experience here, although very quickly. Focusing on blockchain, I understood very early on that blockchain was going to be a challenge to teach, because the first thing that I had to do was to understand what it was, because I wasn't in the industry. For those of you who stick around tomorrow, we'll have a fairly illustrious panel, folks who've been in the blockchain industry since its very beginning, and have a thorough understanding of the technology and its impact on the law. But for most of us in an academic environment, even somebody like me who spent a lot of time around technology, understanding each one of these technologies is a challenge. And blockchain was by far the most difficult technology for me to get my hands around and then to understand how I might teach it to students. One of the courses that we designed was called Digital Commerce and the Law, which it's essentially a contracts course, secured transactions, just about anything to do with the transactional side of technology, including retail sales. That was going to be the point of emphasis, and the focus was going to be on blockchain. And I quickly realized, and the panel that you'll meet tomorrow has agreed with me, it's very difficult if you're not teaching a course on how to actually program blockchain applications. That 15 weeks of blockchain at the law school level probably requires a degree of patience and interest that most law students do not have. So rather than focus for 15 weeks on blockchain, at least in the MLS courses and law school course that was online, we decided to focus on a blockchain over just 3 or 4 weeks. And one of the things that one of the greatest challenges that I found was trying to explain what blockchain was, and more importantly, what its implications were for the law. And I don't know if I've clicked this. I'm going to stop sharing and come back just to double check, because I do have videos and I want to make sure that you can hear them. Yes, we do. So anyway, go back. This is the kind of reaction, the same kind of reaction that I think we get, and I'm trying to go back so it'll automatically launch here. Let me go back. Here we go. Let's see.
56 pass. I wasn't prepared to translate that as I was doing that little tease.
Oh, that's
that little
right.
mark with the A and then the ring around it.
At.
See, that's what I said. Mm-hmm. case that she thought it was about.
Yeah.
Oh,
But I'd never heard
Or
it.
around
I'd never
or
heard it
about-
said. I'd always
That's
seen the
right.
mark, but never heard
Yeah.
it said. And then it sounded stupid when I said it. Violence at NBC.
yeah, I
wouldn't
heard
be
something
around
big
or
fight
about.
up in the lunchroom the other
See,
week.
there it is. Violence at NBC. GE.com. I mean,
Well, Allison should know.
what
do you
is
say about
internet
Allison?
anyway?
Internet is that
Massive computer
right,
network.
the one that's becoming really big now.
What do you mean? That's big. How does one? What do you write to it like mail?
No, a lot of people use it and communicate. I guess they can communicate with NBC writers and producers. Allison, can you explain what internet is?
No, she can't say anything in 10 seconds or less.
Oh, Allison will be in the studio shortly.
What is?
So anyway, I think you get the point. That reaction that reflected in that clip is precisely the reaction that most of my students give me when we get to the blockchain portion of the course, Digital Commerce and the Law. And I also teach a course that's live called Law, Technology, and Entrepreneurship. And we did 2 semesters on developing blockchain technology or designing it. And in those courses, it was over a 15-week period. But the reaction was pretty much the same. And I think you for those of you who don't know much or anything about blockchain, when I give you the definition of blockchain and explain what it is, and I'm going to do that enough so that you can understand the challenges that I'm talking about and trying to teach at the law school. The definition, the cleanest, shortest definition that I like to use is that blockchain is an immutable distributed digital ledger. Now, I'm sure when I say that, for those of you who have no clue what blockchain is, it's meaningless. What possible utility could technology like that have? And yet, most people who are well into technology, most companies that explore, emerging technologies and what technologies are going to impact the world, rank blockchain very highly. The World Economic Council recently suggested that by 2025, that 10% of the global GDP would be related in some way, shape, or form to blockchain. And despite the fact that there's a lot of hype over it, it's still in its early stages. So teaching law students about this technology is also challenging because you cannot buy a textbook on blockchain that is going to be current because the technology changes from month to month, year to year. So let me go back and just kind of describe what blockchain is. Not so much that you understand it, but that you can see the challenges associated with teaching it. We talked about immutability and distributed technology. What blockchain does, it creates unchangeable transactions in a file that cannot be changed. So when you look at Bitcoin, which is a technology, cryptocurrency is a technology that relies on blockchain technology at its foundation, much like email relies on the internet in order to be effective. Cryptocurrencies rely on blockchain in much the same way. Bitcoin was the first cryptocurrency, and the way that Bitcoin works is even today, there is a record of the very first Bitcoin transaction. So every transfer of Bitcoin from one person to another is captured on the Bitcoin blockchain. And in theory, and there are things that you can do like fork a blockchain, split it up if it gets too big or unmanageable. But in theory, with most blockchain technologies, they are designed to be immutable, never changing. And perhaps the more interesting aspect of blockchain technology, and one which makes it very similar to the internet, is that these records, these digital records of data, are captured on multiple computer, multiple computers, sometimes in different networks. And what is the advantage of that? If you have 20 different, and they're called miners, the folks who actually validate and record the transactions. The advantage is you cannot easily hack a blockchain because you can't gain entrance to every single node of the blockchain network simultaneously. If you may get into one of the nodes, but then the other 15 or however many they are preserve the record and make sure that it can't be damaged. Now, having said that, I'm sure you've heard that there have been hacks of blockchain. So what we're really talking about is a degree of difficulty. You know, the encryption that goes into creating a blockchain is far superior than other platforms, primarily because of this distributed technology. And very often you will hear blockchain spoken about as distributed ledger technology. And I'm not going to go into much detail, but basically what happens with each transaction is a transaction is entered, and then you have this network of peer-to-peer computers across the world. And again, that makes sure that it's unhackable. And then this network of computers validates the transactions by solving these very complex mathematical calculations. Unfortunately, one of the downsides of blockchain, at least today, is it's a huge drain on electricity, because the computing power necessary in order to mine blockchain transactions is very, very high. Some of the figures that I've seen is, are that one network, Bitcoin itself, to mine Bitcoin might take the electricity of an entire city at any given point in time. And once these transactions are confirmed, they're clustered into blocks. And then these blocks are chained together, and that's why they're called blockchain. They're introduced on the back end of the chain. And unlike accounting programs where you can go back and you can take your digital pencil and erase a transaction to correct it, you cannot change any record in a blockchain once it's been validated and clustered together and put into the system. Now, what are some of the advantages? Perhaps the greatest one is that they're trustless. You don't have to rely on a bank, any kind of learned intermediary, a bank, a lawyer, governmental entity, to tell you that a particular transaction is valid. And I won't go through each one of these benefits, but perhaps the one that is of the greatest interest to me and will have the greatest immediate impact in the world is that over 2 billion people in the world are bankless. They don't have access to banks. They spend exorbitant amounts of money in order to, of what little money they have, in order to transfer money, receive money, send money. And the greatest potential I see in the short term for blockchain is bringing financial resources to those who don't have them right now, and thereby boosting economies. The other most immediate impact that blockchain is likely to have, particularly in the coronavirus era, is digital identity and confirming, validating who you are and what your credentials are. And I am almost certain that right now there are vaccine passports that are being developed that are tied to the blockchain to validate that people are in fact vaccinated. My recommendation on how you teach it, I'm going to explain how we do it at Chase and at Southern. But the first thing that you have to do, obviously, if you're a professor, instructor, adjunct faculty, is to learn the technology in order to teach it. And this is a little more difficult than learning a case that you can read the case, analyze it, and then go to the next class, because you have to have a kind of overview of what the technology is to be able to really design a course and teach the course. Now, where I go, these are the three best sources that I have found if you're teaching blockchain technology to lay folks and you're trying to understand its impact on the law. Now, you can do a search on blockchain on Google, and you can find a million sources. But these I find, if you're teaching blockchain in law school, are the essential sources. First one, you need a site like Geeks, and there are some other sites that are similar, but Geeks has a ton of videos on YouTube to teach you the technology in the simplest way possible. How much of the technology of blockchain should we teach? I suggest we teach very little of it, right? The programming is just too complicated. But I do believe that much like if we're trying to explain to someone what a smartphone is, and you don't have to understand what's under the hood, you just understand its functionality, then sites like Geeks, which have some free online tutorials, lots of material on YouTube, is a great starting point. Even if you're not teaching blockchain and you're just an attorney who feels like you might want to get into that area of the law, it's a great place. The second place, the most cutting edge place, I think, nationally on blockchain policy and the law, is the Chamber of Digital Commerce. They too have a ton of resources. Here are three examples. Understanding digital tokens, very good. Smart contracts, very good. The blockchain report card. It's a group of stakeholders in the area of blockchain and distributed ledger technology who want to form policy, want to educate, and they have these different alliances that focus on things like digital tokens, smart contracts, and the like. So it's a great resource, and it's kind of an in-between between blockchain and pure law, because you do get a fair amount of information on the technology itself, but more importantly, you get the latest information on how it's impacting society and the law. And then finally, this is a site that I use in all my digital technology courses, because if you need a quick understanding of where the law is in any emerging technology, including blockchain, the National Conference of State Legislatures typically has a scorecard where you can follow along to understand where each state is and what kind of law it is, and then access those laws. Now, how we actually teach it, and I don't know if we need to get into this grassroots, so I'll be very quick about it. We use Top Hat, and the reason we use Top Hat and similar technology like Canvas, which is our NKU's learning platform, is that we needed a virtual textbook for the course that we decided to teach, because as I mentioned, for all of these technologies in my program, the technology and its impact on the law changes radically from year to year. And so to do this course, we created over 100 modules, and I would dare say that at least 25% of them need to be updated each time we teach a course. So we use Top Hat, and because it's asynchronous, we have to provide the materials and do the learning assessments each week. So while we do have a conference that's voluntary for the students each week for 1 hour, and usually a third to a half of the students attend each week in each of these courses, including the blockchain course, we had to come up with a way to impart the information that was engaging and interesting. And one of the things that I found was that the course could not be taught just purely by reading. So we created a series of videos. This is an introductory video that we do, that's an original video that introduces the class to what's happening.
Digital commerce and the law, We
during that
introduced you to
week.
the lifeblood
Let me
of
just
digital
shut up for
commerce,
20 seconds. I
money.
want to hurry through this.
This week, we will examine what money means around the world and how one currency can become a global currency. In particular, we will focus upon Libra, a new digital currency and infrastructure set to launch in 2020 that Facebook proclaims can deliver on the promise of the Internet of Money.
So each week we'll have an introductory video, five minutes or so. That's original, and it kind of gives an overview of what we're going to be doing in the reading and the other videos, and then to replace the lecture, because it's very, very difficult each week to stay current on what's going on in that technology, including in blockchain. We'll use YouTube videos, and normally we structure them into a half-hour format and link them together in order to get the best overview, the most expert advice on what's happening with a particular technology, including blockchain. One of the sources that I absolutely love, it has 2 million subscribers, is Cold Fusion TV, and they have a half dozen really good videos on cryptocurrency, on blockchain, cryptocurrency, recent case uses, and so on. This is what it looks
So this
like.
technology has been called many
And
things. The next stage of the internet.
let me stop
a
for just
trustless
30
system of
seconds
value,
because I think
and the most important
the
technology
quality
ever
of this
invented.
is far superior
Let's put
to
some
what
perspective
you
on
could
this.
get
But first things first,
just
if you
through
don't know what
lecturing.
blockchain actually is, all you need to know is the following, and I'm going to try and avoid the technical terms here. Blockchain is a decentralized, transparent, and verifiable system where value, such as ownership titles, medical records, and cryptocurrency, can be exchanged. This value is stored in something called a digital block.
In the interest of time, I'm going to keep going. So we do the videos, we provide the weekly reading, including law review articles, and we have reading that's required on the quiz, and we kind of measure it in order to meet ABA guidelines on how much time the student should spend outside of the classroom. And then we have optional reading because we do not have an exam. Instead, what we do is we require a 10-page paper at the end of the course. So each week we might provide, as many as 500 pages of material as current as possible, and oftentimes it contains law review articles so that there's a focus on the law on the weekly reading. We have a weekly discussion post. We have weekly quizzes so that we have a learning assessment every week to make sure primarily that the students are just reading the materials and watching the videos. And as I said, at the end of the course, we require, it's not law review quality, but we require a paper primarily because our focus is really trying to get the students to understand the impact of blockchain and blockchain technology on the law and society. And the only way for us to gauge that is not by testing them on the definition of blockchain or the uses of cryptocurrency. And while we cover, the agencies that are developing regulations to govern technology, we're not going to test them on those regulations. And part of the reason why is for those of you who visit us, watch the blockchain panel next week, you're going to find that there's very little regulation in the area, and to the extent there is, it's so complicated that it's a highly specialized area of the law. And I want to leave time for questions and discussions because I only have fewer than 10 minutes. The last thing that we do is we actually, in a couple of courses, we bring in guests who understand blockchain technology. We design blockchain technology. In one course at Southern, we design law blocks, Trust the Chain, and what it was designed to be was a place to store contracts. And we actually developed a technology where we create a will, and the idea was that will would instead of just going into a lawyer's safe, would end up on Factum, which is a very well-known and trusted blockchain provider. And then we had a copyright play in another class, Pitter Patter, that essentially was designed for artists to put their songs and their music on the blockchain. We didn't program it, but we went through the process of actually designing or wireframing what the technology would be. And that's been very, I can't believe how quickly the time has gone. It's almost 30 minutes. So I want to leave about 7 minutes for discussion and anything else. So if anybody has any questions, thoughts, love to hear it. Let's see, there's a chat here. Let's see. Okay. Nope. All right. I don't have any questions, so let me just go ahead, and if anybody has a thought or a question, just interrupt me. Couple of other thoughts on blockchain generally, and on trying to teach blockchain on the wall. One of the things that I have done, and I don't know that there's a budget for it for many of you, but there are blockchain conferences that are excellent. And I have attended about 6 of them, and some of them are free. Each year, for example, Dan Katz at Chicago Kent in Chicago, he had a block legal conference and a fintech conference that dealt with blockchain. And if you have the opportunity, and fortunately some of these things are being presented online. Dan's conferences were free. If you could get to Chicago, it was a great getaway, and you could spend a whole day. And the quality of the experts were superior. So that's on the cheap, the low end of what you might do in spending a day as an academic and immersing yourself in blockchain technology and its future, and networking with folks like me who are interested in blockchain technology. The other thing, on the other end, you've got the Global Blockchain Expo that's in Santa Clara, and there are a number of these. These are more expensive, but the difference in being able to go to a conference like that is you actually get to lay your hands on the technology itself. You get to talk to vendors, you see what they're doing. So depending on what your area of focus is, either it's just getting a basic background on blockchain, its impact on the law. On the one hand, there are conferences that crop up all the time, or really taking a deep dive and going to the big conference. There are a lot of opportunities. Now there's a question from Paul Callister who asked, how do you teach the issues of cryptocurrency and securities and commodities subject to regulation? Typically what we'll do, and again, bear in mind that this is an asynchronous class. We'll use a combination of videos to kind of give an overview of what those regulatory areas are. And I have a friend who actually was general counsel and a co-founder of a company that dealt with the IRS and tracking transactions, for IRS purposes. And right now, we can only, how do I say this? And if you come to tomorrow's panel and you have 2 practicing lawyers in this area, we can only kind of give an overview of where things are with the SEC, with FinCEN, with the IRS, because these regulations are still in development. They're changing, and the way that we're seeing the regulation come out is not by actual promulgated regulations, but by opinion letters or advisory letters that come from these agencies, where particular companies will try to seek input. So we'll give the newest reading on PDF as part of our weekly binder as to where technology is, where regulation is with a particular technology. And blockchain is perhaps the most challenging because there isn't any congressional legislation that really applies to that. And there is just a modicum of state legislation. And as I mentioned, each semester I'll go to the National Conference of State Legislature site and download the latest report card, or I'll go to the Digital Chamber of Commerce. Paul, did I answer your question? hopefully. Any other questions? We only have 2 minutes. Great. Thanks, Paul. You're welcome. So just in closing, I do encourage you to incorporate blockchain into your law and tech curriculum. For those of you who are more fearless than I am, perhaps you can create a full semester course, particularly if you combine it with your computer science department, and perhaps you spend a week teaching the technology, several weeks of actually getting your hands dirty with that. And if you're going to do it, the technology that, if you actually want hands-on technology to learn something that's relevant to the law, I highly recommend getting into smart contracts using Ethereum. And there are a number of platforms, and that the names escape me right now, that have been developed that are user-friendly for lawyers to actually develop smart contracts. And we'll talk more about smart contracts. Probably I should have spent more time about smart contracts. They're the most important, at least from a lawyer's standpoint. But if you're going to actually teach the programming, having a lawyer program a smart contract is not too difficult. Joe, I see you're back. I think I should shut up. And that's it.
Thank you very much, Bob. I was listening in the background, doing a couple things, getting ready for my presentation. I thought it was very good. We will have a time after all the presenters speak for folks to bring in questions for any of the presenters at that point, if you think of them as the program goes forward. I'm going to attempt to share my screen at this point. What I'm going to do before I do that is I'm going to go over the syllabus, look at the syllabus. Then I'm going to go to the, I might show the syllabus off Canvas, or I might show a little bit more updated syllabus but maybe we'll just go off the one on Canvas. It really doesn't, that way it's all self-contained. Then I'll go through some of the modules I have. I'll discuss the course while I'm doing that, take any questions you may have. This is just one example. I used to teach at St. Louis University Law School, and there I taught e-discovery. At that time, I taught a 3-hour e-discovery course. And but when I came to case, I found that we thought it would be the best thing to just introduce it on the 1-hour way of doing things. I've taught it twice already. I've had around 10 students. I'm thinking of doing it a different way, maybe as early this spring. And I'll be talking about that after I go through my course here at Case Western. So let me see if I can get that share screen going. Ready?
Hey, Joe, could you use your headphones, please?
Did people miss me?
No, we heard you, but we hear you much better with your headphones on. Thank you, sir.
I'm sorry. So anyway, I'm going to try to share that screen now. Thanks, Martin, for telling me that. Much better than to go through and everyone not hearing me during my presentation. So I'll go back and attempt to share my screen. I might have questions on how to do this, because I tell you, I've done it several times, but I'm usually asking people, okay, how do I do that? So right now I'm just talking out loud doing it. I hit the screen that I want to go to, and I go back to what else who else can share? That's not quite what I want. Going back to screen share. Okay, I've got that. And then I go down to, I'm sorry, I'm talking out loud, hoping maybe Martin can jump in.
Yeah, Joe, just select this, Joe. So when you click on the share screen button, select the screen you would like to share.
Right.
And then there should be a blue button that says share. Now, I know
yes,
you're on.
that's it. The blue button.
Okay.
I forgot
There
the.
you go, sir.
The blue
Wonderful.
button, yes. Sorry about that, people. I know I'm challenged, but anyway, I have taught 3 courses under Zoom, so somehow I find my way through. But anyway, here's the homepage of electronic discovery that I use at Case Western. Like I said, it's a 1-hour course. I front loaded in the spring, so we beat for the first 7 weeks. And I found even with 1 hour, I can still cover a lot of what I used to cover at St. Louis. Well, one thing you know, I taught it 3 times at St. Louis, and now I'm teaching it a 3rd time here. So you better get it, as you all know, you get a better grasp of the information. But at the end, I'm going to talk about moving it to a 3-hour course and my thoughts on that. And I would like certainly from you all some input. All right, here you can see Canvas, and I know many of you are on a platform such as Canvas, so I don't have to go through that aspect. Let's go to syllabus and try to bring that up. Okay, I think I'm just going to download it. All righty. Hopefully everyone can see this to some extent. Let's see if I can make it just a bit bigger. Okay, so like I said, we front load it, have it on Friday mornings, 9:30 to 11:30. And we go over the basics, right? We cover model 1.1 comment 8, talk about what lawyers are doing out there. It is a practice skills course, so I try to bring in at least 2 speakers. This past spring, I brought in 3, 2 of them, and they stayed the whole hour. They were so good. 2 of them actually worked through a 26F, a meet and confer in class, which students in my evaluations really appreciated. I also brought in a forensic e-discovery expert, which students also was fascinated by. He gave his examples in class. The course covers the 2 Federal Civil Procedure Rule amendments. And then, you know, the Rule 26, meet and confer, 33 interrogatories, 34 productions, 37 sanctions, some big ones, FRE 502, and the EDRM, Electronic Discovery Reference Model. Expectations. Basically, I say that, you know, we're looking for basic professional competence at this point in e-discovery, which most graduate students, graduating law students don't necessarily have. Some pick some up during clerking, but this course will fill that gap. My offers hours, I do not do a textbook. I just attach things into the modules, which I'll show you in a little bit. And I edit the cases so it's a 1-hour course. So there's a paper in the course, so I strongly encourage them to start on the paper early so they can do the necessary reading for that. They will consult me as to what are good sources for their particular topic, and we go through that consultation during the class. Some during the class, but also one-on-one. But I tell them that Wexus, you can go there if you want to read the whole case. Grading, paper is 75%. Actually, this is an old syllabus. I had changed it to 80%, but anyway, I give several sources here off the bat that should cover their area, or certainly given general e-discovery background. I mentioned, of course, Lexis Westlaw, Bloomberg. We take a second to look at that. Legal Tech News, Legal Law Technology Today blog. I know some of you are aware of these and others. Ambrogi's law site, Artificial Lawyer. PLI Plus has a lot of, which is available in our database list, has a lot of e-discovery resources. And I posted 9 different paper topics that they can choose from below that I list. 10-page double-spaced or 5-page single space paper. Again, and 12 pages double space, 6 pages single space. If you want to go a little bit longer with that, I give the time when the paper is due. I give the real basic parameters for the paper. This is not, I tell the students, this is not a legal memoranda, or it doesn't have to be, well, it should be following at least the minimum guidelines I give them, but I'm pretty tolerant. They can use 6 different types of font, for example. I also grade on participation. Those are, acting professionally during class, which you all are aware of. And in addition to that, I will take attendance matters into consideration there. For example, I give them a couple free attendance misses, right? So in 7 classes, it shouldn't be an issue. Most students came to all classes. But also if they're if they're regularly absent, after a couple of those, I'll start knocking them like a half point from the 5 points. We had Max Babeter from Relativity come in. He was in our class the year before with Logical. He appears in person. No, he doesn't appear in person. He appears in Zoom because he's a long ways away. And those have been great presentations. The students worked through the problems given to us this past year by Relativity, and he grades them, which is nice. I mean, I get them too, and we'll send them on to him. Usually it's me and him, and he ends up grading those. And the students do pretty well in those. Now, regarding the schedule, right? First day, discussion of the syllabus and the paper, basic e-discovery terminology, and then I go over the EDRM, right? The Electronic Discovery Reference Model, which is one of the greatest things, in my opinion, since sliced bread. And it really gives them a nice oversight from the beginning. Then I talk about cooperation, meet and confer, the duty to preserve. These are in the next particular class, legal holds. And then I have Max Babeter come into class, and he usually takes about a half an hour to explain what relativity is, about 45 minutes, and then give them a couple hypotheticals that he answers in class, and it goes over well, and students think they're really learning something. And as most of us know, it's overrated learning at this point. I mean, it's not going to be just using a e-discovery platform. I mean, it goes way beyond that. It goes to the law and so forth. But anyway, it makes them feel good, and they like it, and they mention it in their evaluations. I'm going to take a sip just for a second. Third week, legal holds, trigger process. This is when we get ready for about half an hour of the meet and confer. I give them the hypothetical. I gave them, we'll quickly touch on that, the hypothetical, and you can create something like this yourself. I'd be happy to send you my hypothetical. I did to, something I thought would be, they both said the hypothetical was good. But anyway, they could then take that and go to a 26F meeting, opposing sides. The next week, we have the two come in, the two attorneys, Matt Linehan and from Ulmer and Byrne here in town, and Brian Nally from Reminger LPA. They go through it. Like I said, it took the whole class because the students were extremely interested in this. And, you know, they went through it during the first half of class. And then the second half of class, they answered all the students' questions. So I would recommend, if you're doing e-discovery, if you can do a 26F in class, students love it. At least that's my experience, having done it 2 years. And I did that at St. Louis too. And, you know, some attorneys will bring in Jumpstart principles from the Sedona conference that basically, as some of you know, gives you the checklist for everything you need to cover in a meet and confer. Some attorneys haven't. Everybody knows about Jumpstart though. Even the attorneys who don't use it know basically what's on it and have created their own checklist from Jumpstart. Because Jumpstart is really long, and you know, it's very smart, I would say, to adjust it to what you have in your practice or confront in your practice. Next class, we ended up doing data collection, collecting data from social networking sites, both important topics, I think. And of course, since we were late, we lost in here an hour. So we're trying to catch up the rest of the semester. We go over production, rule 34, it's big, Bates numbering and hash values, metadata, cost sharing and cost shifting, spoliation. And then we bring in Donald Wachna. This is something that changed week 7 because I would have been woefully behind. But the thing is, for COVID, I was given the option, as were some other professors, to shorten the number of classes. I think the most would be 2 in recognition of the difficulties and so forth. I did not. I could have taken off week 7 if I didn't have the time, or if I got everything covered in 6 weeks. Unfortunately, I told the students that. I really was gung-ho, and I thought, okay, we can cover this in 6 weeks, no problem. Wow, it took 7 weeks and right up to the end. So a couple people mentioned that on my evaluation. Anyway, what are you going to do? All right, paper topics to choose. Before this year, I gave them a wide range. Right? They could basically do anything except they had to check it with me. I was liberal in my, only a couple, 2 years ago did I say, okay, you got to make this narrower, because they usually fail on breadth. And I was too liberal with that too. I let some things go that they ended up writing. That's why I put the limitation on it this past year as to the amount of pages. Some just went nuts. So as you can see, these are real quick going through these challenges facing parties conducting e-discovery during COVID. I had a couple of papers on that. That was interesting. E-discovery and employment litigation, proportionality, social media, key issues regarding collecting potentially relevant ESI. You know, that steps a business should take to comply with its obligation to preserve ESI. Applying e-discovery and arbitration. One that I put in just for interest, because it was very much during Trump impeachment that just had happened, the insurrection there, especially around impeachment. There were, as many of you know, there were several e-discovery aspects. Got one paper on this. It was quite good. I learned something because we're all busy, and I wasn't paying a daily attention to that stuff. So it was good. And one that a couple students picked, write a paper to your future employer, real or mythical, on the importance of e-discovery in their workplace. And a couple students, one last year, one this year, actually did send it to their future employer. And they both said it was a very favorable reaction. they got to that. All right, that is pretty quickly the syllabus. Let's back out of here and go back to the actual Canvas site. All right, here we are, Canvas again. Let's go over the modules quickly. First day, everybody does this differently who teaches e-discovery and the amount of hours they have, right? First day, I go over sort of almost everything we cover in class real quick. And then I run, before I do that, I go down, here it is. EDRM, if you teach this class, strongly suggest you follow this throughout your course. It's a good reference point to the different things that you're covering on a weekly basis. And, you know, the first part, of course, this is the Duke model. And when Duke took it over, they added the, what do you call it? Information governance reference model. So anyway, students like this. And here's the IGRM. And I go through that too. All right, let's move down. Second week, again, I told you that I'll just take one here. I think I redacted all of them to a certain point. And here I do look, it's kind of ridiculous, but next year I'll just do the lines as opposed to the little star things next to them. But you can see some pages I just knock out. Others, this page, you can see knock out about half of it, but have them read other parts. They tended to like this. Of course, it saves them. Some of those e-discovery cases are voluminous. Going down to the next week, I don't know. Let's see what I'm covering that week in the module. It's coming up. All right, litigation hold. I get in the meet and confer this week, get them ready for the next week. I could slide down, but I don't think I need to. The syllabus lays out, and we went over that of what I cover in the different weeks. Meet and confer. Okay, this is the hypothetical I put together for the 26F. Just the preliminary stuff. I have a woman, Case Western student named Meg Mustier, they call her Mustang Sally, and she's suing this bar. Actually, the company that owns the bar is in Cleveland. It's a Nasty Canasta is a chain centered out of California. But anyway, so she's, you know, deeper pockets. Naturally, she's going after the incorporation. In this case, you have a woman who, along with 4 other Case Western women, to this bar, Nasty Canasta, and she's encouraged to do the nasty, which is basically, you know, getting on top of the bar, whatever that old, I can't even think, one of the names was a bar named Ugly Something. But anyway, dancing up and down on the bar, going across. She was encouraged by the bar tender and also those who were with her and everybody in the bar. They just love seeing someone try to do the nasty. The idea going up there and being somewhat provocative, it matters on the student, whoever does this, very sexist, right? But this stuff still goes on in kids' bars. So during this time, she slips, right? There's naturally beer there. She slips. The next day, she goes out with her friends horseback riding. and, the very next day. And then the day after that, she really starts feeling the pain. I mean, her neck is just terrible, probably exasperated by horseback riding the next day. And she also has another part of her body. I'm trying to think what that part is. Anyway, the back injury. And so now she wants to sue, right? She gets an attorney. They sue Nasty Canasta. And then basically that's the idea. I only have so much time, so I don't want to go into any more. But then of this, and then the two attorneys had this, and they come in and they meet. They do not talk about this. At least they didn't this year. Before they came in, new group of attorneys, which is fine. Now, of course, attorneys can talk about it beforehand. They should probably talk during the whole thing, but both of them said when they came, they said in their practice, the talk before 26F isn't that great. So they thought, okay, this is a class, it's not real clients. We don't really have to do that, and worked out just great. They went through their checklists. One used Jumpstart. They were very prepared, very professional guys. One was a Case Western grad. I can't think of where the other one came from. Good school somewhere. I'm sorry, maybe Ohio State. And they argued. Well, they didn't argue. They collaborated, and that's probably too nice. But anyway, they got through the communication of the 26F, and we're pretty happy with both sides. One side, notedly, gave in a little bit more than the other side, which I thought was interesting. One of the students mentioned that. One was a hard boil, and the other guy was, I wouldn't say soft. He held his ground in some area that he thought was particularly important. Next class, I talk about the Jumpstart outline. I put that in after because I didn't foresee that being talked about by them so much. Sedona Principles, 3rd edition. Everybody's going by Sedona, right? And then just finishing out here, I only have about 10 minutes left, so I really don't want to take any more time on the class, but I do want to talk a little bit about how I'm viewing the class potentially going forward. There's many law schools. I'm not saying it's good or bad, but I'm glad I've been at 2 law schools that did see the value in teaching e-discovery. Both good law schools. I'm not saying that in a derogatory way. I'm not saying that the T14 don't teach e-discovery. I'm not aware. I haven't looked, but I know many good law schools do. I know I got my start in e-discovery from a colleague and good friend, Randy Diamond from Missouri, who's taught this course for many years. And Randy really helped me tremendously in getting my feet on the ground the first year I taught e-discovery. And he also told me I need to bring in, very good idea to bring in a vendor to go through a platform. And that had worked very well. But law students go through discovery in civil and criminal cases in law school. Almost all of them do, right? But very rarely do they participate in discovery demands for on demand or production, right? So they don't get into the e-discovery part of it unless we incorporate that into e-discovery. And I know that some discovery or civil procedure professors are very interested in e-discovery. St. Louis one was particularly interested, and she came to that class on e-discovery. On a couple of the classes she came. So lawyers today, in my opinion, strong opinion, should be instructed in the technology of e-discovery. in a way that is more tuned in than perhaps the way I'm teaching it right now. And I'll get to I'll get to that in a moment. I've been thinking about this for a while. And this I would need to move back to a 3. And maybe some of you are doing this way. I'd love to hear from you, either here or an email. But I think it should be taught in 2 parts. The first part would be sort of what I'm doing already in the 1 hour, covering the basics, moving to, the various topics, right? And the second part of the course would be to use something like a possible workshop to gather, review, and produce e-discovery in sort of a clinic setting or a laboratory, maybe more laboratory. And a large amount of the data and the way of using that we talked about in the first part of the class, they would be in a setting where they'd have the data gathered for the purpose of the course. They can use some of this from their vendor who came in and talked to them in the first part. And then the course would be on various storage devices, and the students would move from step to step with those devices, and they'd be challenged and aided by the instructor, of course, during this practice skills course. It would be, and I would apply for experiential here too. I already have experiential approval for my law practice technology course. And then you get better attendance, right? My law technology practice course has about twice the number of students I have in e-discovery. And I'll tell students they don't have to become experts at this sort of work that they do in the lab, but certainly to the point where they can discuss it intelligently and actually do some of it themselves, because they will have learned the law in part 1 mostly. Second part would be hands-on. And they would talk about making or opposing e-discovery demands, showing or challenging chain of custody in a court setting, otherwise becoming knowledgeable, confronting legal issues involving the subject area. And the course would be tailored something more familiar, not the course, but the lab would be tailored towards something more familiar to law students. I could go to, this is just an example, review the text that control e-discovery regarding the 6th Amendment, the Confrontation Clause, applying to federal criminal matters, and state versions applying to state criminal matters. And then the federal and state rules of evidence to criminal matters and civil matters. And then case law that pertains to this. So we do get in law a little bit, you almost have to, right? And whether explicitly involving e-discovery or applied e-discovery, and the meanings and strengths and weaknesses of the legal positions that they would be presented with. Students would be required, in this case, to submit discovery demands, briefs, or other writings based on the hypothetical proposed. Another hypothetical situation would be a lawyer engaging with e-discovery providers. And it would require the student to ask the proper questions and appraise the vendor, how to appraise, follow-ups, and that would come to a conclusion. That is another hypothetical. You could do both, right? And the class will not produce experts, even with the lab, but it should allow them footing to enter the legal world. And at that point, they might be one of the upcoming stars within some firms that are, woefully lax in this area of the law. So, the idea is lawyers come out of constitutional law, torts, contracts, civil and criminal procedures, and they're used to applying them as new attorneys. And the idea behind this is that, you can have newly graduate attorneys now familiar with e-discovery will apply that the same way they would apply their knowledge from the other subject matters. And it hopefully will prepare attorneys more so than what I have now, prepare them to better practice in e-discovery, having gone through the lessons and examples, the hypotheticals of the lab. So that basically is my proposal for what I'm going to talk to the curriculum committee about a little bit later in the fall, and see if I can get it incorporated for this coming spring. Most likely it won't happen that quickly because it usually takes a year to get through and get approval. And my 1 hour course has already been pegged to time that Friday morning again. So it'll probably be a year from this year. Well, that is coming to the end of my 35 minutes. At this point, I'm going to stop sharing the screen and come back here. I would be happy if there are any questions. I'm going to pop in. Yeah, I don't see any questions at this point. I would suggest that you not only, we have about 5 minutes left for asking questions. I would encourage you to ask them of either Bob or myself during this time. Oh, we have a question. Coyote Ugly. Okay, well, that's good to know. I've never been there. I've just heard things. Any other questions? Well, nope. Okay. No other questions at this point. I do not see a reason. Do you, Bob, to just sit around for 5 minutes? What do you think? Should we just give them an early break, give them 20 minutes? Bob, are you here? No, Bob isn't here. Well, what I'm going to do is give you until, I think it's 10. Almost certain it is. I had the schedule before me and then I flipped it somewhere. So come back at 10. What's that, SJ?
There's a question in the chat. Would the
Oh, okay.
suggestion be to have a series of individual courses focused on specific topics, or one 3-hour course on a variety of topics?
Yeah. I don't know if Bob's back, but that's a good question. What I'm doing here is breaking it down into various topics, with the exception of, well, the technology and law practice. We cover 4 different areas. I cover e-discovery, I cover blockchain, I cover AI, and I cover cybersecurity. I bring guests in. So that's a very crowded class. I have thought of maybe making all those classes 1-hour classes, but as those of us who are directors try to find the time, right? Even professors who aren't directors, it takes a lot of time even to keep up with this type of a class, with new courses coming in and everything. But if you do have the time, or you can spread it around your librarians, if you're a director, that would be something I encouraged. I have tried here at Case Western. It's not like St. Louis, unfortunately, where the librarians could teach before law students. Here, it's only me. I'm the only faculty member. here that can teach. So it would fall all on me. There has been a new cybersecurity 1-hour course, which has come about by an adjunct. And it is, I think there's 10 people signed up for the fall. So that certainly is getting attention. You have to have 5 students at least to teach a course here. So good question. I don't know if I answered it, but I think Bob's still out. So
Joe, I had a comment. This is Heidi.
Hi, Heidi.
Hi, I wondered the extent to which you or others are collaborating with doctrinal faculty or practitioners to perhaps open a dialogue and embed ourselves more in, for example, a federal courts class or a civil procedure class, that sort of thing.
Yeah, that's a great question. I did appear in St. Louis in one civil procedure class. And then the next year that instructor started coming to my classes. And then the third time I taught it there, she said she's up on it. So I didn't go, but there was some collaboration there. Here, the professor has left, but there was a LEAP 3, that's the highest level of our LEAP is our first and second year. Now it's bleeding the third year, basic advanced writing, research and litigation preparation. So he had me come in to talk about e-discovery. The last year he was here, I had a class with him. And that I always enjoy doing that. And it helps me because students start seeing my class as one that they may want to take. And that did help. I have around 10, but I got to find my ways to interest them, especially on Friday morning. Any other questions? We actually ran to, thank you for asking those questions. Come back at 10 o'clock and we will see you then to continue with the program.